The ground is shifting in ways that many never expected, and the sense of certainty that once defined life for U.S. green card holders is rapidly fading. Beneath the feet of millions of green card holders in America, a new era is emerging, one marked by uncertainty, anxiety, and a constant need to stay informed. What was once a symbol of stability and a clear path to citizenship, permanent residency, now faces a maze of new legal and administrative hurdles that can be difficult to navigate, even for the most prepared. Sweeping changes at both the federal and state levels are redefining not only who is welcome in the United States, but also under what conditions they can remain, work, and build their lives. The Trump administration's proposed public charge rule, along with a pending Supreme Court case, threaten to upend long-standing rights and protections that green card holders have relied on for decades. Meanwhile, state laws like Indiana's Senate Bill 76 add yet another layer of complexity, blurring the already fragile lines between state and federal authority, and leaving many immigrants unsure of where they stand. Everyday decisions, like seeking medical care, applying for public benefits, or even traveling abroad to visit family, now carry unexpected risks for immigrants and their families, risks that can have life-altering consequences. These changes don't just affect individuals, they ripple through entire communities, workplaces, and even the nation's sense of identity, shaping how America sees itself and how it is seen by the world. In this rapidly evolving landscape, understanding the new reality for green card holders is crucial, not just for immigrants, but for all Americans who care about the future of their country and the values it stands for. To understand today's changes, we must look back. U.S. immigration policy has swung between openness and restriction, often reflecting the anxieties of the era. The Chinese Exclusion Act of 1882 and the National Origins Quotas of 1924 set early restrictive precedents. The 1965 Immigration and Nationality Act abolished quotas, prioritizing family reunification and skilled labor, and reshaped the system. Later laws, like the 1986 amnesty and the 1996 crackdown, reflected ongoing tension between enforcement and integration. Today's proposals, like the new public charge rule and state-level crackdowns, are the latest swing of this pendulum. They echo past efforts to restrict who is deemed desirable and expand government discretion. The debates of 2026 are deeply rooted in this long, contentious history. At the heart of the new changes is a redefinition of public charge. For decades, this meant denying green cards only to those likely to rely long-term on government cash assistance. The new rule would let officers deny green cards based on a much broader, vaguer set of criteria, including use of non-cash benefits like school lunches or Medicaid for a child. This pits family well-being against immigration prospects, forcing impossible choices. Even the Department of Homeland Security admits the rule could worsen health outcomes and increase poverty. The process becomes subjective, with officers weighing factors like age, health, and finances, creating room for inconsistency and discrimination. For applicants, the path to residency is now fraught with uncertainty and risk. With a certain tendence to their done. The biggest impact of the public charge rule isn't just denials, it's fear. This fear spreads quickly, affecting not only those directly targeted by the rule, but also their loved ones, neighbors, and entire communities. The uncertainty and anxiety caused by the rule can be overwhelming, especially for families who are simply trying to build a better life. Immigrant families, even those with U.S. citizen children, are avoiding essential services out of concern it could jeopardize their status. Many parents are forced to make impossible choices between seeking medical care for a sick child or risking their family's future in the U.S. This fear-driven avoidance extends to programs like food assistance, housing support, and even school-based services. Research shows public benefit use among citizen children with non-citizen parents has dropped sharply. Families are withdrawing from programs that help them stay healthy and stable, even when their children are fully eligible. The consequences are felt not just in statistics, but in the daily lives of children who go without the care and support they need. Millions of American kids may go without medical care or food because of their parents' fears. The impact is especially severe in low-income communities where public programs are often a lifeline. When families pull back from these resources, children's health, nutrition, and development all suffer. This chilling effect ripples outward, straining schools, hospitals, and public health systems. Teachers notice more hungry students, hospitals see more preventable emergencies, and social workers struggle to connect families with help. The entire community feels the pressure. Preventative care is skipped, leading to more expensive emergencies and worse outcomes for everyone. When families delay care, illnesses become more severe and costly to treat, putting additional strain on already overburdened emergency rooms and clinics. Trust between immigrant communities and public institutions erodes, making it harder for teachers, doctors, and social workers to help. When families are afraid to seek assistance, it creates barriers that are difficult to overcome, even for those who want to help. The rule weakens the social safety net for all, not just immigrants. As more families withdraw from public programs, the effectiveness of these services declines, impacting everyone who relies on them, regardless of immigration status. In trying to screen future immigrants, the policy harms families already here. The long-term effects of this fear and withdrawal can last for generations, shaping the health and well-being of entire communities for years to come. Another high-stakes legal battle is unfolding for green card holders across the country. The Supreme Court's review of Bondi versus Lau. This case has captured national attention, as its outcome could reshape the rights of lawful permanent residents returning to the United States after travel abroad. At the heart of the case is a crucial question. Can border officials deny re-entry to green card holders based solely on criminal charges, even if those charges have not led to a conviction? For thousands of families, the answer could mean the difference between stability and separation. The distinction the law makes is critical. Green card holders who are admitted into the country enjoy strong legal protections, including the right to challenge removal in court. But those who are merely paroled in, allowed to enter temporarily, are far more vulnerable to deportation, even if they have lived in the U.S. for years. The government's position is that pending criminal charges, regardless of whether they result in a conviction, are enough to justify denying full admission at the border. They argue this is necessary to protect national security and public safety. Mr. Lau's personal story highlights what's at stake. After traveling abroad, he was paroled, not admitted, upon his return, simply because of unresolved allegations. Later, he faced removal proceedings, even though the charges against him were never proven in court. His experience is not unique, and many green card holders fear similar treatment. The Second Circuit Court of Appeals ruled that only a criminal conviction should be grounds for denying re-entry to a lawful permanent resident. However, other federal courts have reached different conclusions, leading to a patchwork of legal standards across the country and confusion for travelers. Now, the Supreme Court will resolve this split and set a nationwide precedent. Their decision will determine whether green card holders can be kept out of the country based on mere accusations, or if the government must prove its case in court first. If the government prevails, the consequences could be severe. Green card holders with any pending legal trouble, even minor or unproven, could find themselves barred from returning home, separated from their families, jobs, and communities. The border could become a place of legal jeopardy for millions of lawful residents, making every trip abroad a potential risk to their future in America. Bondi v. Lau centers on what it means to be a permanent resident. Advocates argue that green card holders shouldn't lose rights based on mere allegations. Innocent until proven guilty should apply at the border. The government claims broad authority to deny admission for security reasons, even for those with pending charges. The Second Circuit sided with residents, requiring a conviction to deny re-entry. The Supreme Court's review could overturn this, giving border officers sweeping discretion. Any green card holder with a pending charge could be paroled, triggering lengthy legal battles. The outcome will shape the rights and security of millions. State-level crackdowns are intensifying, with Indiana's Senate Bill 76 leading the way. The law forces local agencies to cooperate fully with ICE, removing local discretion and threatening funding for non-compliance. It shields law enforcement from lawsuits for following these mandates. Supporters say it ensures uniform enforcement. Critics warn it will overcrowd jails and strain budgets. More importantly, it erodes trust between police and immigrant communities, making people afraid to report crimes. The bill is part of a broader trend, states competing to appear tough on immigration, often pushing constitutional limits. Recent protests and tragedies in other states have fueled the debate. Indiana's approach signals a new era of aggressive, state-driven enforcement. The result, a climate of fear and uncertainty for all immigrants, including green card holders. Legal experts expect a wave of lawsuits over these new rules. The public charge rule will likely face immediate court challenges for overreaching executive authority and violating due process. Critics argue it discriminates against women, children, and people with disabilities and penalizes citizen children for their parents' status. These cases could tie up the rule for years. The Supreme Court's decision in Bondi versus Lau is unpredictable. Some expect a ruling favoring government power. Others hope for a defense of due process. Whatever the outcome, the decision will set a critical precedent for millions of legal residents. The legal battles ahead will shape the future of U.S. immigration policy. For green card holders, 2026 is a year of caution and vigilance. New federal rules, a pivotal Supreme Court case, and aggressive state laws have created a landscape of risk and uncertainty. Access to accurate information and legal counsel is more important than ever. Community organizations are working to dispel fear and help families make informed choices. Civic engagement is crucial. Advocacy groups are mobilizing to oppose restrictive policies and support legal challenges. The future of immigration policy will be decided in courts, legislatures, and Congress. This is a test of America's character. Will the nation support integration and due process, or build new barriers? For millions navigating this path, staying informed and engaged is essential.